Alex here. Julie Cavanaugh-Bill, the divorce lawyer representing the father, filed a second objection to camera coverage of these proceedings. The first one, Director Paul Malachowski was able to defeat in writing. This particular objection, legal director Jim Jimerson was able to defeat with oral arguments. And I do want to mention some of the details of Julie Cavanaugh-Bill's objection at the end of the video. I will say that I do not believe her articulated reasons are sincere in the slightest. However, just to give her a little bit of credit, they were consistent with the tactics that were attempted by the family law section in 8th Judicial and 2nd Judicial District Court. So it wasn't really anything new. I've seen this kind of stuff before, but it does present an opportunity to go into some of the details as to our redaction policies. So again, if you want to hear more about that, wait until the end of the video and you'll get a lot more detail from me. One last thing, as always, I did reach out to the court for a copy of the JAVS video. We do always want, whenever possible at least, to allow the bench and bar to speak for itself in their own voices through our videos. Unfortunately, there was no JAVS recorded of the camera access portion of the hearing, and so I went ahead and summarized.
All right, and now we are on the record for case DCFN. Again, parties are in court with their respective attorneys. Ms. Cavanaugh-Bill from Mr. Davies from as I was saying, we had the hearing to decide whether to permit the audiovisual coverage. The court did permit that. And as I was saying, that brief hearing was not recorded or covered by our Nevada judges. This one is now, it's my understanding, the camera is here working, but and recording. But as I was saying, at that portion of our hearing today, the parties had stipulated to convert a hearing on a evidentiary hearing on a motion for return of separate property funds that was filed by Ms. in litigation in February this year. That's converted by stipulation to a status hearing. And the parties had informed me they had reached a partial agreement in this case, which would be placed on the record at this hearing. I don't know if a partial agreement means for the whole case or just to deal with this motion, but you can let me know. So, counsel.
Thank you, Judge. Yes, the partial agreement was on this particular issue. So Mr. submitted a cashier's check, or Mr. submitted a cashier's check to submit that to counsel. And then the remainder, there's still some question about what is community property or what was spent on community property expenses. And so that we're hoping to resolve in mediation, which I believe we addressed at the last hearing. And I have reached out to Ms. Cavanaugh-Bill, waiting to hear back on her availability. And with respect to the mediation, we would like to see how many other issues we can resolve. I don't know if we'll reach a global resolution, but the issue that was on the calendar for today, we have partially resolved that and then reserved the remainder to address the mediation. We can't come to an agreement. Obviously, we would have that as part of the trial, which is now scheduled.
All right, and then the cashier's check was for the full amount that she alleged you'd taken?
Not for the full amount, Your Honor, a little bit.
Okay.
It's $130,343.47.
$130,343.47. Okay.
And it's, I agree with Ms. Cavanaugh-Bill as far as my representation that we believe it through the course of mediation, we come to a determination about that particular issue, and if there's any other issues that we have resolved, well, that issue and other issues that would be reserved for trial. I will represent, I think, state will represent that globally, so we send back some bigger pictures. If I'm reading the tea leaves, it looks like we parties are not as far apart as I've seen in the past, and this, so a reason to be optimistic that there might be some headway in this.
Okay. Well, thank you, counsel. So I just want to see, does this completely resolve the motion then?
Well, I think if there's an outstanding balance, then maybe there may be leftover carryover that needs to be resolved in trial.
So I would say resolve the motion, but it doesn't resolve the underlying issues that would still be part of trial if not resolved.
Okay,
For example, the $130,000 for the properties that were returned to her, there's a balance of roughly $120,000 out there. Theoretically, if there was some argument about 50,000 or 10,000 or 5,000, this is a community, it's something that benefit the community.
okay,
There may be an argument about that, and the community not have benefit this ground, particularly. But we're optimistic, we're hopeful that we can whittle that down, hopefully to no balance in disputes. But if we get down to 3 or 4 issues, I suppose the whole package.
okay, thank you for clarifying. I think I understand. So, and I appreciate the parties being able to come to a resolution, at least for right now, for this motion. And then, of course, you know, if there are issues surrounding the balance, which, yes, will be approximately $120,000, that have to be litigated at trial, then we'll do that. Maybe the parties can mediate it. So, okay. Thank you. Do we have anything else for today?
Yes, sir. So I know the court wanted to hear back on the update on the DCS investigation.
Correct.
And so we did receive that yesterday afternoon, and we filed it and sent it over to Mr. Davies as soon as we heard back from the division. And then we submitted it to the court here today, and we've been speaking with Mr. Davies and our clients. And so the request now, they come back and unsubstantiate all allegations. So we attached that communication that Exhibit 1, Your Honor.
Yeah, I did see that filing. Did you get a copy of the filing, Mr. Davis?
I did, Your Honor. I was on the road yesterday, and I saw it this morning at 7 o'clock. I was preparing for today's hearing, so I received it. I got it.
Okay. Yeah, that filing was at 10:12 a.m. And I did get it this afternoon and review it, so.
So we're just asking that the ex parte order that was in place be vacated, and that it just go back to the temporary order, with all the relevant safety conditions that were in there. And with respect to that, we've had some conversations, and he would be doing the sober testing 3 times a day. He was doing it 2 times a day. He would be doing that 3 times a day, and that would start immediately. And it would be on the same schedule the parties had, and so his time would start today. He's going to do it at 5 o'clock, so he's really has time to get the kids, get them prepared, and then mom would have access to call every night before they go to bed, maybe at 7. Dad would continue his contact that he had during mom's times. And the same provisions with regard to, I understand that Ms. already met with Ms. Anderson at that quest. There was some confusion about whether it was family therapy. There was confusion about the no contact order that's still in place in this case. And so Mr. Davies and I have spoken, and we both agree that there needs to be an exception that parties can have contact if it's with respect to family therapy with Ms. Anderson at LifeQuest, so that Ms. Anderson can work with both the parents and those therapists and try to move things along for the family.
Okay.
So at this point, yeah, we're just asking that temporary order is final stamp July 3rd, 2025. That go back into place, and we agree with the additional condition about the increased sober. Oh, and with the phone calls, we do need this to return the middle child's phone, when she has that phone and another phone. That is phone being paid for by Mr. So he'd like to get that phone back, and then we'll ensure that the child has access to a phone, whether in either household, to reach out to either parent.
All right.
So this group would have a full phone.
Question.
Yes.
Going chronologically, Your Honor, my client specifically has times that she wants, so 9 a.m., 2 p.m., 10 p.m. to assure sobriety throughout the visitations. They that makes sense that injuries will throughout the day or two.
All right. Maybe we should take it one at a time. Ms. Cavanaugh-Bill, 9 a.m., 2 p.m., and 10 p.m. Any issues with that?
So by 10 p.m., Mr. is sleeping by then. So could we do 9 or 9:30 p.m. and then 9 a.m. in the morning? That's fine. What you want? He asked for a little earlier.
So
he's asking for a
a little earlier in the evenings.
Yes. Oh, thank you, sorry.
9, so he's just seeking an adjustment from 10 p.m. to 9 or 9:30 p.m.
Sorry. Yes,
Okay, other than that, he can do
yes, sure.
it. 9 a.m., 2 p.m. How about 9 p.m. or 9:30?
The 9:30 we don't have a problem with, or even I think the 9 a.m. if we take, sorry, I apologize. Sorry. We adjust them to 10 p.m. down to like 9:30, 9 p.m. That's not problematic for us. We're going to do an exchange for that, then take that 9 a.m. down to 8 a.m. So that time period just gets, is still addressed.
I understand. Okay, so how's 8 a.m. and 9 p.m.?
Yes,
9, okay, so it would be 8 o'clock a.m., all times specific, 2 p.m., and 9 p.m.
yes.
Okay, gotcha. That's an agreement then.
And just for the record, Your Honor, Ms. continued her testing. And so our understanding, and we've been getting those results on a regular basis, so we appreciate that, and that would continue as well.
Okay.
That's right.
Okay, that was the first thing you addressed, Mr. Davies. The next things?
I agree to the stipulation to carve out an exception for the no contact we have an exception carved out for the family counseling. So that is, it's a two-if.
Sure.
The other issue that's, I don't know if it's a sticking point or not, the phone that Mr. returned, I believe that was one child. My client that says that no longer exists, so she's destroyed it. And so how that plays out. I think there's a flip phone, correct? That I see. And that's my concern was that her locations were being tracked. Obviously, these things are almost like my wife tracks my location on it. And so, but she doesn't want him tracking them. And so what she got in exchange was a T9 or flip, what we used 20 years ago, flip phone. I think that makes sense and we should use that instead.
All right.
The phone, we can deal with what happened to that phone, because I think it cost Mr. $700, he still owes it.
Sounds like that could be a mediation issue as well.
Yes, so if Mr. Davies can talk to his client to see if we could get some kind of proof where she has it, if it's damaged or something. The flip phone issue, that's fine, my client just wants to make sure he has a phone at his house, because I don't think a phone was being returned. So, I mean, he wants to be able to reach out to his son as well.
And I'm sorry, this was which child's phone? So this, the idea would be the flip phone would go with Mr.
During your custodian.
during his time. Sure. Okay, it sounds like she's amenable to that. So, for the flip phone.
Right, yes. And I think, I mean,
Yeah, I know Mr. reaching out and communicating with kids through the app, our Family Wizard app. So I don't know if that's a way they can do it. He said he's fine with the flip phone over for now, but he'd like to be able to replace the phone because he still has a contract and he's still paying for the service, so.
Okay. All right.
I guess I'm getting a little lost on this, because I'm sure Mr. Brown has his own phone, because I have my own phone right here. And the flip phone, the mom can call the phone, and kids are, and my proposal is to use his phone, you call the flip phone, talk to the kids about it. Serious, is that what we're talking about? I missed something.
I think so, but I think recently Mr. Those calls to the flip phone haven't been answered. So I think both parents want to make sure reach out to them.
I do want him to call you both kids' phones because he would be really aggressive and what I find is mentally abusive. So I told him an alternative, he could call them on the recorded line on Family Wizard because he asked differently to report that he has not called them on Family Wizard and they have called him on Family Wizard and he's refused to answer.
And obviously my client disagrees with that, Your Honor. And so I think the main thing is now both parents want to be able to reach the kids when they're in the other parent's care. I think it's reasonable for the parent who doesn't have the kids to be able to reach out once a day. If we can say 7 o'clock, that's after dinner, 7 p.m. And then if the child in particular wants to reach out to the parent, that he has access to do so.
All right. Well, it sounds like this is really not a settlement, this part of it.
I think I have an inclination that now we have a new order, we have a new fresh start perhaps, and we all agree that that flip phone would be the conduit for one person to the other, that we could start fresh. And so go from that. That's my optimistic approach to this.
Okay. Well, if that's the case, then it does sound like you have an agreement on the flip phone issue. So please be mindful always about how you talk to each other and your children, right? I mean, that's where we're trying to get to in this case. Okay, next.
My client, and I'll follow this in, but Gene, that's what the court did, should you complete cooperative co-parenting separation of divorce stated yesterday. This is all I have from the original right here, but I'll have this filed in when I get back to the office.
All right.
On Monday.
Thank you.
FYI. I think that's all our issues.
Did you have anything to report on that, Ms. Cavanaugh-Bill? I know the court had ordered some classes.
Yes, I know that Mr. has been engaging in those. And as soon as he gets certificates of completion, we'll get those in as well.
Okay, thank you. All right. Well, the court will certainly adopt the agreement of the parties now. Are you going to draft an order for my signature on this one?
Yes, I can do that, Your Honor.
And have Mr. Davies review it, please, Ms. Cavanaugh-Bill, and then he can sign off and approve it as to form. My usual procedure is, well, how long do you think it will take to get the order over to you?
It should just be a couple of days, Your Honor.
Okay, and so if parties, the attorneys can work on that order, my usual procedure is after a week of exchanging the order, if the parties aren't able to agree on language, counsel can submit it to the court with their comments on what they agree on and what they don't, and then I review the recording. In this case, I'll talk to my court reporter, and any disputes I'll resolve, and I'll get the order entered because we need to move on.
In my understanding,
Excuse me. I'm sorry, go ahead, please.
my understanding is that then the schedule would start though this afternoon. It was the understanding that both parties understand what this agreement is. Mr. going to get soberly testing they'll switch the phone.
All right.
I think the normal exchange place was the sheriff's department. So,
And under the prior order?
yes, Your Honor.
We have a woman that's at Kavanaugh-Bill.
Yes.
Yes.
Yes, your prior exchange point under section 5 of the prior order, that's the sheriff's office.
Yes, Your Honor. It's only we're gonna do the exchange starting tomorrow morning at 8 a.m.
Okay.
So with the sober league testing, would we do that then before the
I would
exchange?
say 9, I said let's do the testing 9 o'clock tonight, and then 8 o'clock tomorrow morning, so we know that's sober all through the evening.
Yes.
Okay.
Right, she's
I need one at a time.
Sorry. So we'll be all bright-eyed, but she's on tomorrow at 8 o'clock, sheriff's office.
Yes, Your Honor.
All right, sounds good. Thank you. Well, is there anything else then?
Not this time, Your Honor, thank you.
Thank you, Judge.
Okay, thank you. Have a safe trip home, Mr. Davies, and I think that'll.
Stay the night, this is one of my,
Oh, there you go. There you go.
the IE corridor.
There you go.
Thanks, Judge, good to see you.
Okay, yeah. All right. Well, I appreciate counsel. I'll look forward to the provision of that order. Go ahead and get it entered. I appreciate counsel drafting that. And I look forward to making some more progress in this case. The mediation, if you need an order for that, I'll be happy to go ahead and enter an order for that too. And in the meantime, I think we did have our trial set at the last hearing. I think I did an order setting the trial.
Yes, Your Honor.
In January.
Correct. All right. Thank you.
Thanks, Judge.
Court's in this.
Alex here. As promised, I'm going to go through the details of Julie Cavanaugh-Bill's objection, and then I'll explain at the end why I do not believe her motives were sincere. Again, I'm not really picking on Julie Cavanaugh-Bill. All she did is the same thing that a bunch of other divorce lawyers did in the 8th Judicial and 2nd Judicial District Courts. So to me, it's very important to stress that she's not a particularly, bad lawyer. It's basically a playbook. But we'll go through these one by one. So she complained that her client didn't want to be on camera. This is not a family court issue. People don't want to be on camera in any case. And I'm not saying everybody, but just most people generally don't want to be on camera. It's one of the things that has to do with public exposure, and a part of the court process is already stressful enough. Adding cameras to it adds even more stress. I completely sympathize with that. I just want to point out that this isn't a family court issue. You can take the same person, put them in a criminal case, put them in a civil case that has nothing to do with families, and they still won't want to be on camera. So the whole, the job that we're doing to put these cases on video for people to observe, it's not meant for the clients. It's nice that some of them don't mind it. That's appreciated. And I understand that sometimes it may benefit one person or the other, but that's not the point of what we're trying to do. We're trying to educate and inform. So we're not really there to serve them. We're there to serve the public. And it's understandable that people don't want to be on camera. The Supreme Court has already balanced all of this when they put together the Supreme Court rules. It's just important for me to stress to everyone that when I hear people, don't want cameras on their court case, it's very important for me to point out that that's not a family court issue. That's an all kinds of court issue. I mean, even small claims, you can go in there and people won't want to be on camera. So next thing she complained about was a small community. This is a really bad excuse. There's small communities all over the state. I mean, if that is a basis to block camera access, then they may as well change the rules to say you can only film in large cities. And of course, if we did that, then people in the large cities would have, some other generic excuse. The third one is embarrassing public exposure. The only time I really sympathize with this notion of embarrassment is when there's nothing that the person can do, to help it. In many of these cases, the reason they're embarrassed is because of the things that they've done. And so in those particular situations, society, we as a society should tell them, if you don't want to be embarrassed, don't do embarrassing things. I mean, this doesn't always apply to every situation, but a lot of the situations that are filmed, they're embarrassed because they're embarrassed at what they've done, and they would rather, people don't find out about it. Sometimes people say, well, hold on, what about false allegations? That's not a really good excuse, because false allegations come up in any kind of case, criminal cases, non-family court civil cases. So if the issue is false allegations, then once again, you can't really cover any cases anymore, because any case is going to go to trials because one guy is alleging something and the other person saying it didn't happen. So, sympathize with the false allegations portion of the public exposure, but that's the point of covering the case, so that the viewers can find out who won and who lost, who was telling the truth and who was lying. Complaints that the wife is behind the camera coverage. So it might come as a shock to a lot of people. Most of the cases that we cover are not even sent to us by the litigants. Very few cases are actually sent to us by the litigants. I will admit that when it comes to family court, there do happen to be situations where more often than not, it's a litigant that sends it to the media. But that's not really anybody's fault but family court's fault. And that has to do with the extensive sealing of the cases. Because the cases are so extensively sealed, it's very difficult to find out about their existence. And so coincidentally, or perhaps as a side effect of the extensive sealing statutes and rules, it just happens to be that the litigants send the cases more often than not to the media. But that doesn't really have any kind of impact, because when a litigant sends a case to us, that doesn't make us give the litigant special treatment. The case follows the standard our Nevada judges' policies, just like any other case. In fact, if anybody's been following our channel long enough, they will know that there are some litigants who go around social media complaining that they invited us to a case and then we wouldn't go away and it made them look bad. Like, okay, if we're invited to a case, that doesn't mean we have to leave once we're uninvited. I mean, that's one of the things that we consider in covering a case, but it doesn't mean that the litigant that invited us there has control over publication, when it starts, when it stops, if they look good, if they look bad. That's just not how it works. So if this was a case where one of the litigants sent us to the case, this coverage could just as well look very negative on them. And it happens. And it's happened more than once. There just happens to be one case where a particular litigant has been very noisy about inviting us to the case and then not wanting us there after he didn't look good. So anyway, the next one is a pretty good one. So Julie Cavanaugh-Bill says that anybody would know who her client is because the corner of his head was revealed. So two things that I'm going to say. First, we redact the face, not the back of the head, not the side of the head, the face. And if you look at our recent publications with District Court Judge Bryce Duckworth, you will see that this is standard. I mean, this is going back for a while. Early on, we would cover the whole head because there was a lot of paranoia and there were a lot of camera access objections. But at some point, we got to the point where we were like, are we really doing this just to appease the attorneys, or are we going to do what makes sense to the viewers and the public? So the second thing I was going to say is, it's true. It's very likely true that people will know, that people who already know the litigants will know that it's them despite the redactions. The redactions are not meant to make it impossible to know who it is. If they were meant to do that, all it would do is create this cat and mouse game where we would try our best to make it impossible, and then whoever it was that didn't want camera coverage would thwart it. I mean, even if we like hid the voices and stuff, there are insiders within the family court, or even the litigants themselves could share the videos and then claim somebody found out. So the purpose of the redactions, especially when it comes to the parents, is to mitigate, not to make it impossible. And even if, this particular video, even with full redaction of the head, there are still going to be people who know who it is because they know his voice. Or there are still going to be people who know who it is because somebody in the courthouse spreads it to somebody. Or the other litigant does. This is a thing that's going to happen. So it's not to say that the redactions aren't beneficial at all. They're, in my opinion, probably 99.5% of people who watch the video won't know who it is. We're talking about the strangers online who are watching. But yes, it's possible that coworkers, parents, sisters, brothers, the other litigant, the court, those people are going to know who it is. And to say that the redactions don't matter because of that, it's ludicrous, really. Kids are a lot easier to protect because they just aren't going out and about in the world as much. They don't, little kids aren't working at a job. So there's going to be a lot more protection for kids just by the nature that they haven't been alive as long and doing as many things where they would interact with a whole bunch of other adults. So the redactions do their job. They mitigate. And I'm not going to say that the purpose of them is to make it impossible to know who it is. So if the side of the father's head exposed who he was to people who knew who he was, then I can't see how his voice when he testifies isn't going to do the same thing, or how just people just knowing his initials and are curious about Elko. So Julie Cavanaugh-Bill and her complaint on that, I'm sorry, but I do not sympathize with that, because she's complaining that people who know who he is know it's him. They're gonna know it's him anyway. They just are. And so it's great that like huge swaths of the viewers won't know who he is, but people close to him will know who he is. And I don't know if you guys know about this, but like going way back into the beginning of the founding of this country, all of the towns were small towns. People went to the courthouse and got all kinds of gossip and information and then spread it with each other. I mean, just because times are different now in 2025 and a lot less people pay attention to court activities doesn't mean that, there's just magical new privilege to nobody knowing who you are. This case has a camera on it. This case has media attention. We're here to educate and inform. We're not here to humiliate or insult this person, but it's just one of those things that can happen if certain allegations are raised in certain cases and they've done certain things that they regret doing. We can't help that. Mr. Malachowski, we did ask him about whether he got an email from her. He said he didn't. So this was not really debated in court. Our attorney who appeared at the hearing, Mr. Jimerson, pointed out that there was no real reason to discuss it, because even if I had gotten that sent to me by Paul Malachowski, I would have declined to do anything about it because the policy was complied with. District Court Judge Al Kacin did request that for this particular case, we do redact the full head, and we told him we will. So this particular case will get special treatment. We will redact the full head because that's what the judges ordered. But I just wanted to be clear, and Mr. Jimerson made it clear that we did comply with our policies, and that Julie Cavanaugh-Bill telling the court that we didn't was just plain not true. Violation of, next on the list is no objection from the mom. I did forget to mention that there was no camera access objection from Richard Davies on this hearing nor the prior hearing. Oh, I'm not sure I mentioned this, but District Court Judge Al Kacin did request that we republish the prior video with the redaction applied to the side of the head and the back of the head, and we did comply with that. So if anybody saw that last video published for a second time, that's the reason we published it for the second time. So I did mention that, in my opinion, Julie Cavanaugh-Bill was not sincere, and she complained that the video was already out there and that it's too late for her client and therefore we shouldn't be allowed to film anymore. Well, I would have thought that this was sincere if she didn't say the same thing the first time around. We hadn't even filmed yet. So these objections that she raises are the same objections that she raised the first time around. We hadn't filmed, so at that time, I can't understand why she would want total to block all access to the hearing. If the divorce lawyers that were against camera coverage were more particular about what they were trying to protect, I would think that they were sincere. But time and time again, in fact, I've lost count of how many objections we've received from divorce lawyers. Not a single objection, not one objection asked for a partial redaction. Actually, no, that was a stipulation, so that doesn't count. Not one objection asked for a partial redaction. Every single objection that a divorce lawyer has filed, every single one has asked to block all access total access, total closure, no camera coverage whatsoever. And that's one of the biggest reasons that I don't believe that this effort to block, transparency, camera access to these cases is insincere. I would love to one day find the first family court lawyer ever to ask to protect very specific things. And maybe when that day comes, we'll celebrate, but it hasn't come yet. The other reason that I do not believe Julie Cavanaugh-Bill is sincere is because she told the court that she sent us a subpoena, which the News Shield statute renders our communications with our sources privileged. And this has extended to online media since the case, I think it's Toll v. Wilson. This notion that, a subpoena is going to get sent to ONJ to find out who it is that's talking to us, I call this the witch hunt tactic. This is not the first time I've seen this attempted. Again, guys, like towards the beginning of the resistance, we'll call it, from the divorce lawyers in a Judicial District Court, Second Judicial District Court, there was this idea that whoever it is that's talking to the media needs to be demonized, exposed to the judge, and punished. And there were a few witch hunts that were attempted early on. I haven't seen a witch hunt for a while now. I guess Julie Cavanaugh-Bill didn't get the memo or something, but she tried that old trick. And really, the point of even asking or even mentioning this in open court was to just intimidate. It sends a message, if you talk to the media, we're going to do a subpoena, find out what you told them and all that stuff. I don't think that, first off, I checked with our registered agent. They said they didn't get anything. So we haven't gotten a subpoena as far as I know. But really, I think just saying it out loud, making sure everybody heard her say it, and I don't really think it's so much the court staff or the judge as the litigants themselves. And it's just sort of, in my very strong opinion, the purpose of saying that was to get it so that people don't talk to us. And like I said, guys, this isn't the first time that this has been insinuated, but anyway, it's disappointing that this is happening in the 4th Judicial District Court, but I don't think it's going to happen for long. Just like what happened in 8th Judicial, just like what happened in 2nd Judicial. They'll try a few times, and once it just doesn't work, they'll stop. So hopefully this is the last objection that we get in this case. I am not going to hold my breath on it. We do have one more hearing coming up, and more likely than not, we will get a third objection to camera access. But we'll see.